So welcome all of us and all of you to the ILW webinar on EB-5, and it is the act is now in effect, and it means some things, and some things of those are clear, some are not, and we hope that perhaps we can shed some more light on that today. We are all in the United States, and we are all bound, of course, by American law. So I want to make sure everyone understands that nothing today is legal advice, nothing today is financial advice. Everything is purely education. It's designed to provide ideas for people to ponder over and think about. And again, a reminder, this is a professional event. It's intended for those in the EB-5 industry, regardless of whether they are attorneys or on the project side or in any other way connected to the EB-5 industry. It's not intended for investors or immigrants. So please keep that in mind. The sequence and structure is very clear. I'm going to be posing a few questions, just a few, a small handful, to each of our panelists, and they will offer such thoughts as they have on those issues. And that we hope at the end we will have plenty of time, for questions going forward. Now, before I turn this over and get the formal process started, we're going to pause for a 30-second advertisement. So I'm inviting my colleague Srikanth to please take it away from here.
Thanks, Sam. In addition to our EB-5 industry event in New York City on June 15th, whose details I'm about to put in the chat, we continue to do investor events in USA and Asia. We're doing events in Delhi, India on June 23rd, Charlotte, North Carolina on June 24th, and Detroit, Michigan on June 26th. To exhibit and speak at these events, you can reach us at webmaster@ilw.com. Thank you.
Thank you, Srikanth. That was certainly under 30 seconds. And I mean, look, our panelists need no introduction, but I'm going to take the liberty of taking 15 seconds to introduce each of them to you. I mean, Robert Devine is, I suspect he's the most respected person in this industry. I can see that from our audience reaction, and he's a wonderful practitioner. I mean, many of his clients have told me that he is an amazing attorney to have, have as a person representing them. But I call him sometimes a little bit to chagrin as something I value as a scholar and a gentleman. And he's very welcome here, and we appreciate your kindness coming here. Matt Gordon is a real brain trust, one-person brain trust in EB-5. He's the inventor of the set-aside concept. He was the first person to discuss it publicly in Congress or elsewhere, to the best of my knowledge, and also the reviver. He hates me calling him the inventor of the pool direct, but the reviver of the pool direct concept. So we have certainly a lot of intellectual firepower here. And let's turn to them. So let me begin with Robert. This act has many provisions, and each one of them we learn as we go. One of them has to do with sustainment of investment. The requirements before this act became law and after this act became law may or may not be the same. Can you help us understand the difference, and what are the implications thereof in terms of the differences, if any? Please take it away, sir.
Sure, Sam. One of the most important requirements that was in the law before the 2022 law was the requirement that the investor sustain the investment to the end of the conditional residence period. Now, that meant people tried to understand what did that mean, and they were understandably being very conservative about it early on, and basically assumed that you had to keep the money in the original project to the end of the adjudication of the IA-29. Well, that got changed over time under the old law with USCIS clarifying its interpretation and saying that, well, for one, the end of the conditional residence period is just when the A-29 is due, not when it's adjudicated. So that saves 4 or 5 years on the back end, so you can get your money back earlier. But then they also clarified that the money could come back from the original project to the NCE before the end of conditional residence, but the investor just had to keep it invested in the NCE, and the NCE would then have to redeploy into something else. But this obligation to keep the money sustained in the NCE and through that into one or more job creating entities created a lot of opportunity for a lot of people to profit off of that money for a long time. And that's still going on. But the new law only prospectively, meaning only applying the change to investors who file their I-526 after March 15 of 2022, so under the new law, they don't have to sustain to the end of conditional residence. That was just stricken from the law. And instead, in the beginning of the act, it basically says that the capital that the foreign investor invests needs to be expected to remain invested for at least 2 years. And that's the only mention of any obligation to keep money invested for any period of time. There is a reference later on in the law, in the new law, to the sustainment period. I don't know whether whoever wrote that was realizing that the old sustainment period had been deleted. And I'm not sure a whole lot of people realized what has changed. And even when I did a summary of the law, kind of for everybody, and did a, kind of a track changes on the statute, I missed it. I missed it because the way it was worded was very easy to miss. But it's definitely, my friend Michael Harris pointed out to me that I had overlooked this, and it's a big deal. So we don't know when the 2 years starts. Is it from when the investor puts the money in the NCE, or is it when the NCE gives the money to the JCE, or is it when the JCE spends the money in the last bit of the money? And I would say conservatively, it's probably smart to count the 2 years from when the money gets spent in the JCE before the investor could get that money back. But it seems that an investor could actually get paid back before they get an I-526 adjudication. That's a game changer. I think in a way, it could be an unfortunate game changer in terms of the quality of investments that get offered, especially if investors press and choose investments that are focused on a short duration of use of their money, because a lot of good projects won't be able to do that. Maybe there are some people who are talking about trying to get Congress to change that because people didn't realize that was in there. We'll have to see.
Wow. So you see, I mean, the statute is still relatively new, and we all learn as we go. And Robert reads it and rereads it, and here's what we found. So hopefully that is something that people can think about. Let's turn to Matt.
And Sam, just before you jump in the question, I mean, that was a great summary, Robert. And I think it's important to point out to people that's what the law permits. But sponsors can, by contract, require a longer hold period in the investment, because we're structuring things now, and I know most of the projects really wouldn't be interested in 48-month capital. The market's sort of used to a 5-year hold, and so that's what we're building into all of our documentation. But for self-sponsored EB-5, single direct like that, you can easily see where people could take advantage of that in a very genuine, good way, and not be as beholden to it. But it'll be important to get some interpretation as to, as Robert pointed out, when exactly does the clock start, because it is definitely ambiguous.
Matt, thank you for that clarification. There are a lot of offerings, particularly from clients of mine, who are just going to hold the money longer than that because they need to in order to make the economics work.
Right. Very good. So let's turn to Matt for another question on another area. Agents all over the world, and including people here, sometimes broker dealers, sometimes not, who have been promoting various projects from time to time, are all concerned about this new idea of registration. What is this registration all about, especially in terms of foreign agents? We've had a number of foreign agents reach out saying, look, I'm licensed in my country. How is it all going to work? Any thoughts on that, Matt?
Sure. So, I mean, this was a really important part of the integrity measures that people have been trying to get past for a long, long time. I mean, at its very minimum, disclosure is now codified. It was really required under anti-fraud theories, because all of the amounts of money were material, relationships between agents and sponsors was material, and it always really should have been disclosed. Now there's no question about it. Not only does it need to be disclosed, it requires a specific investor certification that you have to present it to them. They have to sign off on all the information about the related parties. So that's in effect as of the enactment. Now, what's really interesting is, we now have yet another form of security regulator in the United States known as USCIS. So while there's a savings clause which says, yeah, everything that the SEC and state regulators has to do still gets to do it, but now there's a specific registration requirement, so almost like a FINRA-like requirement for foreign agents. And who knows what this is really going to look like, because this agency has really no experience doing anything as such. I'm actually a little surprised they didn't try to borrow a little bit of infrastructure from the SEC or FINRA to get something done. But again, this is overseas. So this is really brand new territory. Now, as I read through it in the statute, it says that everyone has to comply with rules that will be promulgated. And but there, you could almost read the language and say, well, does that mean that no one can use an agent until they make rules? Now, that might be a bit of a stressed reading of the language. But then again, if you look at how the agency has interpreted the redesignation issue, maybe they'll take the position that you cannot even use an agency now until they promulgate rules. There's some language I think you can kind of go on both sides. So until we have policy guidance on how the agency is going to interpret it, things can get very dangerous, because if a sponsor works with an agent and they're deemed to be in violation of the rules, there's lots of penalties which are pretty extreme. So again, we're in a period of where nobody really knows how USCIS is going to interpret this, let alone other agencies, and it's really uncertain for people. It's a little bit of a dangerous time to start working. So certainly people need to comply with the disclosure requirements, and then in working with agents, it's kind of at your peril for the moment.
Sam,
Wow. Yes,
Sam,
go ahead, sir.
Yeah, on the issue, I can't wait to see the practical fallout of this disclosure requirement. I mean, I'm hearing so far from clients who are starting to deal with agents that they're demanding incredible amounts of participation as a compensation for their activity. And I'll just be amazed if investors will sign on to a deal where they fully understand incredible amounts of compensation that their broker is getting, that they're not, way more upside to the broker than to the investor. So I can't wait to see if that really plays out, or whether the reality of disclosure knocks down some of the compensation. The other point is that I think that a written agreement, for now, a written agreement could say that a promoter who's working with an issuer will register as soon as that process becomes available. I mean, if the process doesn't exist, I don't see how the government can say you can't use somebody who's not failing to comply. It's just not something that can be complied with. But Matt's got a point. We don't know.
Sure, absolutely. And apart from that being the theme that I'm hearing so far, I mean, of course, the market has to speak on a number of issues. And of course, the agent compensation is going to be one amongst them. And there'll be supply and demand forces that will move the needle this way or that way, depending on how things go. So that's certainly open for all of us to learn together about. And let's turn now once again to Robert on the only game in town at the moment, at least most people say, is the direct solar projects, because that's what the USCIS seems to be willing to accept. And the new act, what does it say about direct solar projects in terms of compliance requirements for such situations where it's one investor, and what are the compliance requirements there, sir? Well,
this is where the way the law is written, when you back up and look at the headings, it looks like a lot of the new subsections of section 203(b)(5) were meant for regional centers until you get down to about well, at least L, maybe R. I mean, it's pretty clear that L, which deals with sources of funds, was meant to apply to everybody, every investor. But there are other provisions that even have a heading that says this, that it's something about regional center deals. But then when you read the actual text, it says that it applies to all new commercial enterprises. All regional centers, new commercial enterprises, job creating enterprises. And those provisions could be found to apply even to direct solo where there's no regional center involved. Perfect example would be the subsection H, which prohibits certain listed prohibited persons from being involved in an NCE. With a direct solo, there's no project application that gets made. So there's no mechanism other than the filing of the I-526 by the investor where any showing about the involved persons in the NCE not being prohibited persons could be made. This is done in the regional center context with this new form I-956H. But it's possible that USCIS could debar a new commercial enterprise in a solo direct if somebody involved is, on the list of prohibited persons under subsection H. The subsection K that deals with promoters doesn't have a heading that speaks specifically to regional centers. And by the way, headings don't really matter anyway. The Supreme Court just ruled in another case that headings don't count. They're just fluff, and the text is what matters. So it may be that direct solos that are sold through promoters need to comply with those provisions that Matt just summarized. And then finally, Q, subsection Q, that deals with, that says that an NCE needs to have a separate account for the EB-5 money, separate from all the other money that may be coming into the project, and requires an independent third-party fund administrator. This could be found to apply to a solo direct, and anybody who's offering a solo direct needs to be thinking about trying to comply with these things just to be safe.
Yeah, no, that's a great point. And we were actually just going through that today, as a matter of fact, because some of the language seems to suggest, okay, it's under the regional center heading. Some of the language talks about pooled investments and job creation entities and things that are very regional center and parlance. But at the same time, the very beginning of that section says new commercial enterprise. It doesn't say a new commercial enterprise associated with a regional center. Right. I think there's about 100 or maybe 1,000 instances of sloppy drafting in this legislation, and it's just going to create umpteen numbers of confusion. And and again, do you want to be hyper conservative? But then again, if you have a single investor in a single in a project and you don't have segregated accounts, it's sort of like, well, all the money is getting spent in that entity anyway. So what's the point of it? What's the harm? What's the foul? Even your comment on debarment. Debarment of what? How do you debar an NCE? An NCE just qualifies the immigrant for an immigration benefit. It's not part of anything. So what are you kicking it out of? Again, this stuff is all sloppy drafting and it makes no sense, but it is a valid question.
Well, on that, what the agency would be kicking an NCE out of is kicking an NCE out of the investor's qualification for a visa. And so
right.
The investor would have to either go hug the leg of another NCE somehow, which means they would have to get their money back.
Right.
So you're to a different NCE or something.
But look at the incentive structure. So you're going to punish the investor for the sponsor's sin.
Well, that would not be me.
I don't mean you, but I mean that's the remedy that effectively you're talking about. So it makes no sense. Of course, it makes sense in a regional center context because you punish the regional center for violating the requirements. But again, it would seem absurd that they take the position that you have a fund administration requirement for solo direct, but maybe they do.
Wow.
Well,
the
real fun will be in finding out whether this subsection M that Matt is talking about, that has the kind of innocent investor protection, is going to apply to any pre-enactment, pre-March 15, 2022 investors. If it does, then conceivably there could be JPEAK investors who could try to take advantage of that. They've got to somehow show that somebody was debarred or should be considered to have been debarred, maybe by the court that handled the receivership and did debar Mr. Quiros himself from various activities. It'll be interesting to see if anybody can can take advantage of that.
No, it's a very good point. And as we can see now, even though it's sloppily drafted or not, it is the law of the land. And as they say, sometimes that's why the courthouse was built, right? Judges are going to read the act, and sloppily or not, the judges are going to tell us what the acts mean, and we'll learn as we go. And the agency, of course, will have its own take from time to time. But let's turn to Matt now on an issue which may or may not be controversial. Pool direct, as you rightly point out, was not invented by you. Right? It was something that was existing in the 1990s, but you certainly were the reviver of the concept of pool direct about 10 years ago. And a lot of people, there were a lot of pool direct projects. By our count, almost 60 projects between July of 2022 and 21 and March of 2022, about 60 projects in the market. Now, pool direct, is it dead, or is there some kind of structuring mechanism that is something that is in your bag of tricks, sir?
Well, I will say categorically, under the language of the statute, pool direct is dead, but that doesn't mean we're out of business. So interestingly, some of the early projects I did, I thought to myself, well, we can actually just take a whole bunch of investors in a direct project, put them all in an NCE and make it work. No problem from a corporate law, structuring standpoint. But I said, early in the days, I said, well, what if investors don't want to be partnered with people they don't know? Why don't we create a synthetic pool and house them all in separate legal entities? We call them special purpose vehicles, but all just essentially separate LPs or separate LLCs. So some of our early projects, we did just that way. So they were actually all single investor direct projects. So, and I'd called that at the time, quasi pooled, or, because it's really not a pool, but the organizations actually are orchestrated and function together in concert. So that way they get the benefits of being part of a larger organization, but at the same time, legally, they're structured distinctly. They have segregation of liabilities, et cetera, and so forth, and not common ownership. So there's ways you can pool risk across organizations, for example, and there's ways you can pool benefits. So anything you can do inside a larger box, you can do pretty much inside a series of smaller boxes. So that's the quasi-pooled structure, which I've been using for 10, 15 years at this point, and there's no reason legally why it violates the words of the statute. I could see USCIS maybe getting upset about this if you really take an existing company or rather a company, the idea of a company, and start putting every 10 chairs inside a different LLC. That might get them, but you certainly can do it in a way that complies. And then the question is, how aggressive do you want to get to to risking a fight with USCIS? Now, on the flip side, you have concepts like what I'll call a serial direct. And these have been done for a long time as well. So we're working right now with one restaurant organization. Every location is a separate NCE. They're all geographically distinct from one another. Now they do have a common management company, but there's no problem with that. So you can have the quasi-pooled, you can have the serial pooled. So while the traditional pool direct of multiple investors inside the same direct NCE, not affiliated with a regional center, is dead as a doornail, it doesn't mean that non-regional center-based structures don't have a lot of life left in them.
Okay, wow. So that's a lot of food for thought. And we do have more questions for our panelists, but we're going to take a quick pause to run a poll. Can I ask technology to please launch the poll? And lots of questions have come in. I think we got at least half a dozen questions already. We'll turn to the questions shortly, but let me request all members of the audience to please pay a minute's attention to the poll. There are some multiple choice questions, and would you please register your impression? Even if you've done it before, what we are seeing is there has been some changes in people's thoughts on these topics, and we're going to be publishing that for all of you in the coming days and weeks. To study what it looked like immediately after the act and what it looks like now. So is a multiple choice. The first one talks about the size of the capital market that we have today. And people had different views at one time, and their views seem to be shifting. The second question, there's only three questions. The second question is about what are the top two sources of this capital that will be coming in. And we're giving you multiple choices, including none of the above. So you don't have to necessarily go with the countries that we have put together. And then finally, the question is, of clarity. Everyone has been seeking clarity, and that's why we all, hang on every single word that Robert and Matt and others, who are greatly knowledgeable in the industry say about the act. And already today they've shown that there's a lot to be learned here. But everyone wants clarity. The question is, when are we going to get it? And so those three different multiple choices. A lot of people, about 45%, have already registered their thoughts on this issue. May I request all the others to, those who want to participate, there's some are still finishing it. It won't take too long. We're up to 48% now. And maybe if one or two more want to complete it, that's all we're going to wait for. And we're at 50%. So gone. I can see people are still doing it 52%, but we are going to call it a day in a second or two more. And let's see if somebody wants to hit send. Nobody's hitting send. Okay, we're done. Let's end the poll, the results. Let's see what we see right now. People today are saying that there's a clear consensus of it being between $500 million to $1 billion. That would be a reduction. The market in 2019 was about $1.25 to $1.5 billion. So we're looking at about a 50% smaller market. That's what the consensus appears to be. In terms of where will they all come from, it seems to be everyone is all over the place. All over the place in terms of there's no particular one of those 7 choices which even cracks the 20% mark. And in terms of when will we have clarity, now we do have a clear winner here. Most people think it's going to be a long time before we have some idea about when will we have some idea of what this all means. Now let me turn back, because you'll come here to listen not to my reading out the poll, but to our thoughts of our wonderful panelists here. Let me turn to Robert. Fund administration, you mentioned it before, and it's something that the Act now makes a big deal about. What are the requirements for fund administration, sir?
Okay, first, the NCE must set up a separate account that holds the EB-5 capital, and that capital can only be released upon, well, it has to be sort of simultaneously controlled or co-controlled by a fund administrator, an independent third-party fund administrator. And that person has to sign off in writing on the release of any money. It either has to go back to the investor if there's some kind of refund situation, or it goes on to the job creating enterprise for expenditure in the project, complying with the business plan and the offering documents. And if the job creating entity is an affiliate of the regional center or the NCE, then there actually also has to be a separate account at the JCE level. So it would come out of the separate account of the NCE into the separate account of the JCE, and then expended from there, only with a sign off from the fund administrator after making sure that it's going to be spent on what it's supposed to be spent on. The fund administrator can be any of several different types of people. It could be a lawyer or an accountant or a registered broker-dealer or registered investment advisor, or somebody else who somehow legitimately makes a business being a fund administrator. There are several companies out there that do make a business of being a fund administrator and have been doing this in the EB-5 industry even before this law. And this law drives more business their way. And I honestly think that it's generally a very good thing. The worst things that happened in EB-5 under prior law was the mismanagement, mishandling, the diversion, it's USCIS favorite term, of capital to things that it wasn't supposed to be used for. And I actually had some clients, some former clients, who fell to the temptation to do that, and it's really bad. And so this should make that basically impossible, and I think it should add a lot of integrity to the program. People are going to have to get used to it, and but there it is. There are a few exceptions. One is it's kind of the government has to allow a waiver. It's called if it says, the law says, if the NCE or the JCE gets annual audited financial statements. people could differ about. We'll have to see what USCIS makes of that word or. I think it was written with the intention that, with the understanding that there might be some NCEs that don't have a separate JCE. And so the NCE alone getting an audited financial statement would be enough. But if there is an NCE and a JCE, I think the only safe interpretation right now is that they're both getting audited financial statements. It doesn't seem to me to be sufficient that you could get out of the fund administrator requirement by having just the NCE have an audited financial statement showing, yeah, we sent the money to the JCE with no accounting of what happened at the JCE level. There's another waiver that USCIS has to talk to the SEC about, get its mind around, make some rules about where a broker-dealer could serve in a certain way. And that's going to be a long time before that could happen.
All right, that's a lot there to chew on. And I'll editorialize here just for a little bit about the word or. In the English language, every language is different, right? In Algonquin, for example, the words for snow, they say they have 27 words for snow. Fresh snow, 2 hours old, is different from a snow which is 8 hours old. There's a different word for snow which is 1 day old, right? And every language has its own strengths and weaknesses. And the word or, it's a pet peeve of mine, is one of the weaknesses of the English language. And in formal logic, there's a distinction between a soft or, which is an and or, and a hard or, which is either or. And in mathematics, of course, they use the spelling ORR for the hard or and OR for the soft or, right? So that makes it a lot easier to understand. And I always dread it when in regulations and in law people use the word or, because it can really and legitimately confuse the hell out of anyone using the English language. So if any regulator or legislator is hearing this, please do not use the word or in what you write as rules for the rest of society. So that's my editorial. Thank you for listening. Let's
Very well done, Sam. Thank you.
Thank you, sir. All right, let's turn to Matt. It's a philosophical point, perhaps. I mean, what is USCIS doing here? I mean, they're saying everyone has to do this 956 form, and there's a 956H. I believe there's a new form coming called a 956F. I believe F for Frank. That's been rumored. And I mean, this agency is not known for fast adjudication. What are they doing? Is there something going on, sir?
So I think this is part of a deep state conspiracy on the part of USCIS to murder the regional center program. This goes on a long time, way back when there were problems in the California Service Center that everyone remembers, and they moved it to Washington, and people couldn't ferret out all the gremlins, and adjudication time grew and grew, notwithstanding nice laws from Congress, which said it must be adjudicated in 6 months or less. Here we are. What are we up to, guys? 72? So and here you are. This is an agency of the executive branch, which is supposed to take the laws of Congress and implement them according to congressional intent. I think if you kind of surveyed 100 people in the immigration space involved with EB-5, you'd get 102 people agreeing that it was the intent of Congress to continue the old regional centers under the new program and then have them, come up with higher levels of compliance. No one would ever have guessed they thought Congress meant to kill the entire pre-existing regional center program and all the RCs, 600, 700 of them that were still active, and then make them start the entire rigmarole over again, which I think Suzanne published a nice article showing it would take about 4,000 years at current adjudication rates based on 924s to actually process just to get with the existing ones back in business. So it's like, oh my goodness, this is the attrition strategy of the era. Now, on top of that, not only that, they have to figure out how to actually regulate foreign agents, which they have no experience and no infrastructure, about. So maybe it'll take them 3, 5, 7 years before they get around to figuring out, rulemaking around that. Now also they have to take back targeted employment area adjudication. and they have to figure out how they're going to do it. Now, they have some experience with that, of course, but it doesn't mean it has to go fast. So a lot of the market is sort of priced out without being able to be in a TEA. It will hurt people. Even the $250,000 is meaningful as a delta for a lot. So there's just all these opportunities for the agency, if they so desire, which they seem to so desire, to try to kill this puppy on the vine. And it's kind of sad because, you know, it took many years for the industry and Congress to sort of get around themselves and say, okay, this is what we want moving forward. And it's really not bad. As you've said, Sam, a couple of times, almost no one is happy with everything. Therefore, it's probably on the road to being a good thing. This is the start of 2.0, and it can actually help rebirth this industry, which has helped raise billions of dollars in capital and creating tens of thousands of jobs. And here, the agency, notwithstanding clear congressional intent, does seem to be, you know, at odds with it. And that to me is beyond their purview and really inappropriate. But unfortunately, you know, as we can see, and I see a lot of questions on the court cases, I don't know if this is going to be resolved very quickly, and it might. And even if it is, we all know USCIS, you know, says damn the torpedoes to the courts very often, and they'll just keep on finding ways to throw, you know, a wrench in the works and make this a very difficult program to operate in on the regional center side.
All right. Well, it's a tough time in the industry, but we hope it's harbinger perhaps of much better days to come. Hopefully folks in the agency listen to some of this kind of feedback that Matt and others are giving to it, including Suzanne, and maybe there might be a better day. But we are going to turn to your questions shortly. There's about half a dozen questions that have come in. You can put those questions in the chat box down or also in the Q&A box, whichever you prefer. And I'm going to select as many of them as I can to post to the panelists, but not before we have one last 30-second advertising break. Why don't I turn this over now to my colleague, Srikanth? Please take it away.
Thanks, Sam. In addition to our EB-5 industry event in New York City on June 15th, whose details are in the chat, we continue to do investor events in the USA and in Asia. We're doing events in Delhi, India on June 23rd, Charlotte, North Carolina on June 24th, and Detroit, Michigan on June 26th. To exhibit and speak at these events, you can reach us at webmaster@ilw.com. Thank you.
Thank you, Srikanth. And now let's turn to your questions. And again, we'll take as many as we can. We still have about at least, I'm hoping 10 more minutes to go. And I'm going to try to put in as much as I can to the panelists. So let's turn to a question that I've had several people call me about. They say, well, it's a lot of money, more than $17,000 to apply for the 956. And what if I go ahead and I file my application, the 956 application, and then later on, one of the court cases turns out they get a TRO. Do I get my money back from USCIS? That's the question.
I doubt it.
I haven't seen USCIS create a refund department, so.
All right, so that's your answer. It's a good question, but that's the answer. Now let's turn to another question which keeps coming up again and again. Let's say somebody had a 526 pending for some time, and they are in the United States in lawful status. Can they apply for adjustment of status?
Yes. Well, if they're eligible for adjustment of status under the rules of adjustment of status, which are
exactly
narrow.
Exactly.
Yeah.
Exactly.
Yeah, that's whether they invested before this law was enacted or after.
Right. As long as their visa category is current.
Yes, thank you.
Exactly.
In other words, as long as they weren't born in China.
Well, basically, yeah.
Right. So visa category current, otherwise eligible for adjustment, in lawful status in the United States, pending 526, you're golden.
I would say in lawful non-immigrant visa status.
Non-immigrant visa status. Non-immigrant visa status.
Yeah.
Absolutely correct. Non-immigrant visa status.
Well, actually, Sam, let's make this a meaningful question because I know a lot of people are thinking it. So you have a prospective client, Robert, and they said, okay, I'm going to come from whatever country on a B1, B2, hang out for a good 3 months and then file. Can I do this then?
Well, I mean, one of the published legitimate activities of a business visitor is to look for an investment. And if you come here and you find one, and then you become aware, well, wait a minute, I could go ahead and just apply and stay and apply for adjustment of status at the same time. I can't say why that's wrong. I mean, you run the risk it's a risk management exercise, this is, that some adjudication officer at USCIS will say, well, wait a minute, you applied so soon after you came in. It looks like you had a preconceived intent to stay, and that was a violation of your representation of yourself as a visitor. And either find you to have made a misrepresentation and you're therefore inadmissible forever, or I just make a decision that you are in my discretion, that you're not eligible for adjustment of status. That latter decision is very rarely made, but it could happen. I think on the whole, people could do that.
Okay.
I think if they already had their 526 pending before they use a visitor visa and come in and then apply for adjustment of status, that's a different ballgame. That has a lot more risk associated with it.
For sure. For sure.
All right. No, I get it. So everyone, remember, there's two issues that our panelists just pointed out. There's the law, and then there's the risk management and the reality of adjudicators' inherent discretion, right? So as far as a matter of law is concerned, it's a matter of intent. And I think the controlling decision is a matter of Hoseinpur, if I remember correctly. And on the other hand, adjudicators are human beings and they may have some views about what your intent was. So it's a risk management issue. Let's turn to a question which I'm sure is in many people's minds. The 956 process, let's say two people apply. One business was doing regional center operations for, let's say, 10 years and are veterans of the industry. Another one is a complete newbie, just getting started, very first time in the EB-5 world. Is USCIS going to treat them both the same way, or is one going to get priority processing over the other? Any thoughts on that?
Well, I sent a white paper to USCIS a couple of weeks before the first listening session and made the case that what they should do is to accept their previous adjudication of the geographic claims of a regional center that previously was designated as a regional center. So if I had a regional center before and I make a new application, I include a copy of my previous approval, because the standard for geographic designation is exactly the same. It's all the words jumbled up a little bit, but they're the same words as before under the RIA. Then I should just be given that designation, and all I need to do is show that I have all the policies and procedures in place, or that I've just described the policies and procedures sufficiently, and I can be designated. And that could take about 10 minutes for a USCIS officer, and that could handle the whole problem that the industry has presented in these lawsuits. And I'm shocked and amazed and appalled that the agency has not taken my advice, but there it is. I haven't seen any hint that they will.
Well, look, I mean, I urge the agency to listen to its former and first chief counsel. He has a good point here. And actually, we have a statement from someone who used to work for USCIS, and that's what they purport to say, and that they have a suggestion on one of the questions. I'm going to read that out in a minute, but I do want to remind people we do have another 4 or 5 minutes. If you want to put in any questions that you have, please go ahead and put them in either in the chat box or in the Q&A. But here's the comment from this person who says, quote, I'm going to just read it out. Quote, I worked for USCIS. Yes, you can get refund from USCIS, but you will have to spend double the money with an attorney to get the refund, unquote. Okay, so for what it's worth. So after all, there are people who, they actually have another very, very good question. I'm going to turn to that. But once again, I want to remind people about please putting your questions into either the chat box or the Q&A. We've got a couple of minutes to spare. I'm going to read it out because I think the flavor comes better this way. Quote, for China mainland born applicants, the June visa bulletin shows that both the direct EB-5 and the regional center EB-5 are subject to the visa backlog. However, the visa bulletin also shows that for reserved rural or infrastructure projects, their priority date is current. What if a China mainland born investor invests in a direct EB-5 project within a rural area? Is this investor subject to the visa backlog?
Well, if this investor right now is in the United States, then they could file the 526 and file for adjustment of status, because there is on its face under the visa bulletin no waiting list for any person on the planet who's applying for a visa reserved category.
Right. It also includes the high unemployment area. So the only backlog is really pre-investment, pre-law from prior to the new law, investors.
Well, no, it
Everybody,
could be a new investor in a non-TEA.
right.
They would have. They would
Yeah,
be
yeah, in the
subject to that.
non-TA, that's right, that's right. But if you're investing in the TA in any of the three categories, high unemployment, rural, or infrastructure, then you're in the set-aside category.
But what we have to understand is that people have to get, if you're going to get a visa or get adjustment of status approved, you're going to have to get a 526 approved. And by the time one person might get approved, there might be thousands of others who also have, and some of those might, I mean, it's a race. It's a race that where you're placing the queue technically is when you filed your I-526, but if somebody who came after you got done before you, they could end up taking your place. The administration of these set-asides, these visa reserves, is going to be very surprising to people and so unpredictable. The one thing you can know is if you're here and you apply for adjustment, then you can, you can get an immediate benefit.
Right.
Beyond that, there's some uncertainty associated with it, and the earlier the better. The earlier you get in, the earlier you file, the earlier is your place in the queue, and the earlier you may get adjudicated and be able to take advantage of that.
Yeah, and that point is such an earth-shattering change. You can get, the EAD and travel parole, which for most people are the overwhelming proportion of benefits associated with lawful permanent residency anyway. So even if there is an extended wait after that fact, they've really captured a tremendous amount of the benefit.
Mm-hmm.
All right, so let's turn to another question, which is relating to the question that one of the comments that Robert just made. About how will these new things work, the set-asides and these new concepts that we have around the set-asides. One of the concepts is priority processing for rural and high unemployment and et cetera, and infrastructure. What is priority processing? Do we have any thoughts on that at all?
Yeah.
Oh, I think they're going to slow play everything. But other than that, I mean, I can't even, there's so many stories you hear about where, I have one client who, and actually we worked on this together, Robert, with an expedite, and he checks in with me every now and then. And so we won the expedite form 6 months ago through a pretty, huge effort on everyone's part. And yet he shows me a friend of his in a regular direct project, no expedite, who got adjudicated in 90 days. Go figure. So I don't even try to, prognosticate on anything associated with adjudication times. It's really pretty impossible.
All right, very good. So look, whether you like it or not, this is what the thoughts are, and these are very knowledgeable people. So I urge you to think very carefully about the issues they're commenting on. A question from an attorney. I know he asks to adjust here, because one of the great benefits now is to be able to adjust if you're here lawfully. To adjust here, can the dependents adjust if they are here in lawful non-immigrant status, but the principal investor is still back in the home country?
No, the rules, when you read the rules all together, the principal has to be the one who drives the deal. And if you want to depend on a principal who's outside the United States, that person has to actually enter the US before a derivative could apply for adjustment of status.
Yeah, and that person has to enter with the requisite intent.
Mm-hmm.
Yeah. Having said that, I've seen a case that I didn't file, but somebody brought to me, where what I just said happened, where the parents were undergoing visa processing and the child was in the US and applied for adjustment of status without waiting for them to get here. And ultimately, that child's adjustment was granted. Now, I can't explain it. It just happened, and I think it's an aberration and a mistake. But it could happen.
The service makes errors, and you shouldn't be making any kind of strategy based upon the possibility of the service making an error.
Well, and then they can undo the error if they ever figure it out. That's
exactly. They have many tools available at many steps of the process to correct their own errors, and it's not a good idea to bank on the service making an error. Now, a question from an attorney: is there a list of designated high unemployment areas When can we get such a list if it doesn't exist at this time?
So
There's a couple of websites that people
Yeah.
have where you can plug it into and it'll give you the answer, and that's a pretty good answer.
Well, it's interesting. I was just doing that and I went across 3 different websites and 2 agreed and 1 didn't.
Right.
So now remember, it's USCIS that determines it, and they're going to look at the evidence. And there's a few different ways to kind of parse different type, between the ACS data and just, different types of data that's out there to establish high unemployment. When we're talking rural, it's kind of easy. Infrastructure is going to be, what is in the definitions. But when it comes to high unemployment, there's definitely a little bit of art to the science. And so, our strategy would be to go and actually, get one of the economists to actually go through the data and write a supporting letter or memo to say this is what it is, because then USCIS has to buy into it. So make it really easy from them. But I was actually pretty surprised to see some of the databases not in agreement.
Right. So there is some unknowns here which people should be aware of, but I'm hoping that our conversation today and hearing from our distinguished panelists today has given all of you some food for thought and helped clarify some of the issues that are, I'm sure, on everyone's minds. But we have run out of time. We have impinged upon the courtesy of our panelists enough. We promised them it would not be an hour, and we are closing in on the hour. So I do need to call it a day here at this point, but I want to thank everyone for participating in the poll. We will be sending out contact information for our panelists should you wish to engage them in problems and questions that are before you. And we'll also be sending out the results of the polls to everyone by email in the coming days. And thank you everyone for listening. And with that, this is goodbye from ILW.com.